first machine-made art, if you will. And so the court case challenged the photograph itself to sort of prove itself as an art form.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Please welcome your host, Leticia Caminero.
Hello and welcome to episode 12, the last episode of the second season. Today we're going to talk about photography and copyright. Let's listen to our guest.
Hi, my name is David Newhoff. I am an American, as in a United States American, because there's more than one kind. And I'm 54 years old, and I am a writer and often a copyright advocate as well.
Thank you so much, David, for joining us today to talk about your career and your book. Before we talk about further on this very interesting title, I love the title, by the way, of your book.
Thank you.
It's Who Invented Oscar Wilde? The Photograph at the Center of Modern American Copyright. Before we talk about that, let's talk about your career. How did you end up being a writer and finally working towards copyright awareness?
Like any creative person, backwards and sideways, but in no particular order. But my background is in filmmaking and video production and a lot of media and communications. I've always written something throughout my career, whether it's scripts or essays or whatever it is I'm writing. And I worked in the film and video business in New York City predominantly for over 25 years. And I sort of backed into copyright advocacy partly through a friend, because a very good friend of mine from college named Sandra Eistars was the head of Copyright Alliance at the time. And we just got talking, and that was at about the same time that the whole SOPA PIPA battle was raging on the internet. And that particular story got me interested simultaneously in two things. One, copyright advocacy, but also because of the scope and scale and hyperbole thrown at trying to kill those two bills, and eventually did kill those two bills. I also became interested in what the internet was doing to distort reality. And this was back in 2011, 2012 when that was going on. So yes, I was advocating the passage of those laws because I thought that they did something important to fight piracy, but also just the kind of level of antagonism thrown predominantly by the big tech industry at those. And I became very concerned. I thought, what's happening to our democratic process if the truth is distorted this rapidly? God, I don't know what I was thinking. So anyway, and those two things kind of converged and became the blog that I write called The Illusion of More, that launched in the summer of 2012. And yes, I write about copyright there. And then I also write about sort of digital age issues, whether it's Section 230 topics or, I take a sort of skeptical view of what many people call tech utopianism, right? This idea that the internet has made everything better, which was a very popular idea about 4 years ago. And then after a while, after acquiring enough knowledge about copyright in general, and circa 2018, I thought I really would like to write a nonfiction book, that there was nothing really out there, for the general reader. There's a lot of academic books and there's sort of a lot of how-to books, in the world of copyright. But I didn't think there was much on for a general reader that sort of, covered some of the history and some of the core ideas that was accessible for anybody who was a non-attorney. And that was the goal.
So it's right. Refreshing to find a book like yours in such an interesting topic. Who invented Oscar Wilde? The photo made the author, or the author made the photo? It's important.
Well, since you put it that way, and since you mentioned the title, I'll start with where the title came from. I got to give a little bit of background. So the decision I made in terms of the focus of this book was to put the case called Burrow-Giles v. Cerrone at the center, make that a centerpiece of the book. Now, attorneys know this case because it's a landmark case, but for anybody listening, in 1882, when Oscar Wilde came to first to New York, but to America to do his lecture tour that lasted about a year. He took a series of photographs with the then most famous celebrity photographer of the era, of the age, named Napoleon Cerrone. He had a studio in New York City at Union Square. And one of those photographs, number 18, was infringed by a lithographic company I can get into the details, but suffice to say it was infringed. And Cerrone sued, and that became a landmark copyright case because the defendant alleged at the time that photography was not properly protected by copyright, that it was unconstitutional for Congress to have protected the photograph, even though they had written it into the law in 1865. Nobody had really challenged the thinking behind it. And that was important because what the case did was it asked in many ways the same question that a lot of the artists and critics of the period asked, which is there any authorship in a photograph? This machine, light strikes a plate and this machine makes the picture. Where's the human authorship in this photograph? And it was the first time it was the first machine made art, if you will. And so the court case challenged the photograph itself to sort of prove itself as an art form. So the legal question also sort of converged with the cultural and artistic question that had already been bubbling really ever since photography was introduced to the market. Sorry to go back to the title though. It comes from a somewhat sarcastic headline in the New York Times. The day that oral arguments began at the Supreme Court in 1883, the New York Times posted a headline, "Did Cerrone invent Oscar Wilde?" And they were being a little bit cheeky about it, right? And of course, but without necessarily meaning to, I think that editor really kind of put his finger on it because that was the question: is what does it mean to invent a piece of work? And of course, at the time, the word invent but today, no copyright attorney would ever say invent in context. They would say authorship or author. But at the time, invent and author were a little more interchangeable. Mm-hmm. And if you read the briefs from the case, even Cerrone's attorney makes a whole big deal about what it means to invent art, which again, we would never do that today, because that's patent law. But anyway, that's where the title came from, and that question was really. Had, like I say, didn't really mean to, but kind of put its finger on the question of what is authorship? What is human authorship? And as a result of, the outcome of the case, the protection of photographs, it did change copyright doctrine. And I was intrigued by the fact that it did so just at the threshold of the 20th century, when, of course, machines and creativity would machine-made art, if you will, or machines playing a role in the production of art would explode. Motion pictures were very close behind. And of course, we know the rest, on into the digital age. So, and then the fact that of all people, the other thing that intrigued me about it was that it happened to be Oscar Wilde, because I think photographs they're inherently paradoxical, legally and creatively, right? A photograph tells the truth, but it's also an expressive form. Is it the author saying something, or is the photograph just copying reality? That's a legal paradox because, of course, we know photographs can be evidence in a court case, and so on the one hand, if they can be evidence, how are they expressive? But what intrigued me about that is, of all the people it could have been, it happened to be Oscar Wilde, who is a paradoxical figure himself and happened to be at a particularly paradoxical moment in his life at that time, because, and I explained in the book why he came to America, which was essentially to play a character. Yes, he was giving a lecture as Oscar Wilde, but he was also here to sort of play a character to help promote a Gilbert Sullivan show called Patience. And that character was something of a self-satire. It was in a way, Wilde was sort of sent to America to mock himself, which is a strange place to be in life, So he was here he needed the money, he needed the job. But he was there to sort of promote himself as an author who had yet to write any of his famous works. And at the same time, he was there in the employ of Gilbert and Sullivan being somebody who was essentially mocking Oscar Wilde. so I thought, well, all that sounds very attractive. So I decided to make that the centerpiece of a book talking about.
I couldn't imagine someone better to focus on that as such an enigmatic persona as Oscar Wilde, because we're still discovering his life, about everything that he lived throughout his art and also in his personal life. He was a person ahead of his time in many things, and also very troubled in the situation that he had to live. Quite an angle to
Yes.
your book. Can you talk about other landmark cases that establish copyright here in the U.S.?
Well, I don't, I was thinking about this, and, first of all, I need to stipulate that my book very much focuses, and I admit it from the beginning, on American copyright. As you know, there's copyright differs around the world, and there was no way I was going to try to truly embrace all that in a relatively small book for general readers. And so, I don't really think of landmark cases per se establishing copyright, but what I did focus on was this longstanding debate, that goes all the way back to sort of proto-copyright regimes, which is in England, which is copyright a creature of statute? Is it just created by virtue of the statute, or is it a natural right that the statute protects? And that battle rages on to this day. You see it all the time on the internet. Needless to say, the critics of copyright tend to favor a statutory, creature of statute view, and pro-copyright folks are a little bit more amenable to a natural rights view. But even those lines are certainly not straight. But in terms of cases, I did focus in England in the 18th century. In 1769, there was a case called Miller v. Taylor. And that, kind of what happened was, after the Statute of Anne was passed in 1710 in England, which is considered the first author-centric copyright law in Anglo-American law, right? It also created this sort of challenge for the booksellers versus the sort of independent booksellers and the stationers' company booksellers, the tradesmen of the guild. Sorry. Mm-hmm. And by virtue of the Statute of Anne passing, what happened is, it puts very specific limitations on, copyright protected for 14 years. And it then creates this problem of, well, did the copyright exist prior to the statute? So did it, does it extinguish the common law copyright? And did the common law copyright even exist? So the two cases that sort of determine this doctrine were, Miller v. Taylor in 1769 essentially affirmed that authors had copyrights in the common law and they were in perpetuity, and that it was mostly codified by the statute. But then along comes another case both over the same poem, by the way, both over a poem called The Seasons. And in 1774, Donald V. Beckett says that the statute effectively extinguished the common law right once the work is published. That unpublished work had a perpetual copyright under common law, but that once it's published, then it entered the terms of the statute, and the statute effectively extinguished that perpetual right, which tilts toward a copyright protection as a creature of statute. Of course, part of the challenge is that in England, all the proto copyright regimes had nothing to do with modern copyright at all, right? They were about royal prerogatives to control work. They were about censorship based on religious doctrine. They were about so many different things, and also giving a guild exclusivity, which all the guilds had exclusivity. That was the purpose of the guilds. But they didn't really compare to modern copyright, let alone American copyright. And then, of course, that same question arose in the first Supreme Court case in the United States, which was Wheaton v. Peters in 1834, really over the text of Supreme Court the reports of the Supreme Court. The court ruled unanimously that, of course, those reports are not subject to copyright anyway, but they also, constituent to the ruling, held that copyright in the United States is a creature of statute. Though, as I say in the book, I think that the reasoning is actually kind of flawed. I mentioned that because I mentioned that the reasoning in Peters is that the word secure in the copyright statute, in the IP statute, to secure the rights, the Peters court held that that word meant it wasn't a word of origination, meaning that that the statute had effectively created the law. I have issue with that, as I say in the book, because perhaps the case I make is that the most prominent use of the word secure in the American Constitution is the preamble, to secure the blessings of liberty. I guarantee that the framers didn't mean that those blessings of liberty were created by the document, that they were saying that we're protecting the blessings of liberty, not creating the blessings of liberty. So it seemed like an odd interpretation to me. But anyway, they're not going to overturn Wheaton v. Peters anytime soon. And it doesn't really matter because that debate still rages on. It's not an easy question.
Yeah. What should be protected? What is creation? What is not a creation? So it's always raining on that. And now we're walking towards the AI creations. Should they be protected, or the creator of the AI is in fact the author of the creation done by the AI? So now we have more questions than answers.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Right. Yeah, I as you know, I address AI in the later chapters of the book, and that's one of the questions a lot of people ask is an AI work protected? I think the answer will if the person you're asking owns the AI, they're going to say yes.
Of course.
It's in their interest. My own view is that it isn't. That AI produce work. I mean, I make the point fairly consistently that it's pretty hard to have the foundation of copyright is predicated on human authorship.
Humans.
And photography makes that point because it sits right in the middle there between human and machine. But at the very least, it's a collaboration between human and machine.
You also mentioned, I think it was a gorilla. The one that took the photo.
The monkey selfie.
Monkey selfie, yes.
Yes.
Tell us a bit about that, the monkey selfie.
I do have a section in the book addressing the monkey selfie because, of course, the case does rate, or it's not even a case. The whole online battle
controversy.
Controversy is a good word. It definitely raises that same question, right? Is there authorship? And of course, as many people know, the organization PETA tried very hard to make a case that a monkey can author a photograph. And for the same reason, I personally could not get behind that for the same reason that that the copyright is predicated on human authorship, and of course it's doctrine in the U.S. as well.
Yeah, of course.
It's part of the Copyright Office compendium that very explicitly states what
human creation.
Exactly. Unfortunately, I also make the case that David Slater, the photographer, in that story, was effectively, I think, stripped of his copyrights by the internet, for want of a better way to put it. That it was as far as the information that is available, and really it's David's story, because we don't have there are no other witnesses other than the monkey, or monkeys, I should say. But the way that he describes taking the photograph, and setting up to take the photograph, and also there's more than one. In my opinion, it qualifies as authorship in a photograph, and that really what happened is the whole story of the monkey selfie sort of got out of hand
online, and then Wikipedia made a whole big.
The internet is very good for escalating situations.
You think?
Let's talk about one of America's favorites, universal favorites, actually, Mickey Mouse. How is Mickey Mouse responsible for the copyright we have today?
The only reason Mickey Mouse comes up in terms of copyright is the Copyright Term Extension Act of 1998, which as many people know, extended the copyright from life of the author plus 50 years to life of the author plus 70 years. But the answer to the question is what Mickey Mouse has to do with that is nothing. Mickey Mouse obviously is shorthand for meaning the Disney Corporation. We're not really talking
of course.
But it is a myth out there in the universe, in the blogosphere. The story in many people's heads is, the term on Mickey was about to expire. And Disney pushed really, really hard for the Copyright Term Extension Act. And they, practically knocked on Sonny Bono's door. And the next thing you knew, copyright was expanded for 20 years. And then some people take that story and say, and tomorrow the studios will be pushing for another extension, which, first of all, on that last part, there's no evidence of that. Nobody's pushing for a longer copyright, but also, as I describe in the book in this section, the truth is much more boring than that. First of all, the United States has almost entirely throughout its copyright history played catch up with the rest of the world in terms of term length. First, it was slow to adopt a life of the author plus regime at all, which, for anyone who's a non-attorney listening, we used to have terms that were just a fixed term, 28 years or whatever. But we were not the first to come up with the life of the author plus kind of regime. That those had been proposed in other countries and adopted in other countries long before the United States did. And proposals I talk about, the English parliamentarian Thomas Telford, who was the first English lawmaker to propose a life of the author type regime, and also a fairly long extension at the time. He was proposing a 60-year, and that was 130 years prior to a lot of what we're talking about. So the whole idea of term length and a life of the author plus and all they existed before the U.S. in what's called the Berne Convention, which the U.S. took about 103 years, I think, to get around to finally joining. And at that point, by the time it went into effect the following year, the EU is already about to form. And so the EU extends their copyright terms by 20 years. They establish a life of the author plus 70. And then the US is again playing catch up. That's the kind of boring answer as to why the US adopted the Copyright Term Extension Act, is to say we need to catch back up to our European partners with whom we do a lot of trade and have the same terms so that American authors are not disadvantaged and, so that we have the same, parity basically with our trading partners. And in fact, it was only named after Sonny Bono because he had died in a skiing accident. He wasn't the lead author. None of this is to say that Disney was not very much in favor of the extension. They were definitely in favor of the extension. I'm sure they were very vocally in favor of the extension, as were many other studios and other copyright holders. But it just isn't the case that Mickey Mouse had anything to do.
We are debunking the Mickey Mouse myth.
Yeah, well, I try to debunk the Mickey Mouse myth. It doesn't make, as you know, it doesn't make a myth die. I mean, a firmly held belief is not easy to unstick.
Yeah, that's true. Even with all the evidence.
Doesn't matter.
Yeah. So finally, to quote your book, in its highest creative use, the technology enables new forms of expression. With these new forms of expressions, are we reinforcing copyright protection, or are we making copyright obsolete?
Well, Well, I'm going to answer that partly with a question back at you because, I mean, just for context, that quote comes from a section where I'm discussing deep fakes.
Yeah.
Which I obviously am describing as a very low use of technology in my view, for the most part. Mm-hmm. I mean, it doesn't have to be, but today
it usually is.
It usually is. And I'm making the point that of course we can use it for high use, but I just wanted to clarify when we, in a broader sense, sort of new forms of creativity or new forms of creative expression can mean a lot of different things. So in context to your question, are you asking about new forms like mashups and, kind of YouTuber type stuff, or are you asking about other, or is it a more general?
No, it's the first one, about the deep fakes, the mashup, the YouTubeization of life,
right,
and
right.
everything on that area.
The truth is that things, phenomena like YouTube have created a rationale for more use of existing works. And some of those uses are very clever. They're, we could say a lot of nice things about it. Some of them aren't, but some of them are wonderful. And so the sort of copyright critic crowd says, well, look at all these new uses. Copyright is really ill-equipped to handle this. I don't think that it renders it obsolete at all. For one thing, a lot of those creators, as we've already seen, have discovered the value of copyright for themselves. If you look at some of the intramural battles on YouTube itself, where YouTuber A has his or her work used by YouTuber B without permission, they suddenly realize, oh, copyright actually means something.
That's for something.
It actually has a function here, and that's why YouTube actually created what they call their copyright match system for that purpose, so that the sort of YouTuber v YouTuber, if you will, sort of conflicts can be worked out. So same principle. Obviously, anybody who spends time and energy and creativity working on something has a certain interest in, whether it's financial or personal. So no, in general, I don't think it makes it obsolete. Yes, we do see, it makes it more complicated in many ways from an enforcement standpoint, because there's no question, every 5 minutes somebody's making a video that uses a piece of music or a piece of artwork or a clip from a film. In practical terms, a lot of copyright owners simply decide, I will let that go because it's really not doing me any harm, because it actually would be a fair use, or it's just too much to address. I don't think, though, that just simply because the volume is so high that then people should, kind of jump to the next logical conclusion that, oh, then copyright is obsolete because it's completely unenforceable. Google and company would like everybody to come to that conclusion, because they don't like any friction in the flow of anything. It's in their interest. But no, I don't think that's the correct conclusion to come to. And I would also add that, if we broaden our thinking about sort of quote new forms of expression, right? I also think about other phenomena, like think about how, say, binge watching and the explosion of what's happened on what we used to call television, the small screen experience, right, has changed dramatically. It's a quasi-internet story because really it's just a different pipe. But, instead of a coaxial cable, it's an Ethernet cable. It doesn't really matter. But, the dynamics have changed. And so things like binge watching and the Netflix experience haven't just changed our habits as viewers. They've also changed the way productions get done. They change the way scripts are written. They open up possibilities for works getting done that otherwise wouldn't get done. You look at something like Queen's Gambit, which is a great example, something that you would never make a feature film that long. You couldn't get away with it. And yet it also doesn't have to be an ongoing series that might run 5-6 years to succeed. It can be a limited, what we used to call a miniseries, but with tremendous production values and appeal to the kind of audiences that we have today because of the way the technologies have changed.
So, and there's no way copyright isn't part of is obsolete anywhere in that entire story.
Of course.
Not on any level.
It comes from a book first, and then it got adapted, and second, right? So copyright is in every step of the way, and then in the streaming as well. And it's interesting, the streaming itself, how it started from the obscure side of let's stream this illegal content for people recording inside the local cinema or just taking a DVD and uploading it, and then it catch on, and the content maker realized that this is how consumers want to watch and enjoy entertainment. They want to do it freely through their homes, and they're willing to pay for quality. So let's make that happen.
Yeah, no, I think that's true. I mean, I don't know that I normally don't give the sort of pirates that much credit.
Everything has something good.
Yes. No, I mean, the only thing I qualify there is because, I mean, it's an argument that's been around for a while, which is that, if say the mainstream producers or the for-profit producers would just figure out what the market wants, then the market would stop pirating. Well, we've already seen that that's just not true. The motion picture industry, for example, as you know, has adapted tremendously.
Yes.
And sometimes as I've mentioned a couple of times on the blog, if you're a millennial and younger, and you think all this is sure, but you think all this stuff is normal and this amount of volume is normal. But when you forget that it wasn't that long ago that, I would go to Blockbuster, spend a few dollars and rent a few movies, at least one of which I would never get around to watching. And then I would turn it late and pay too much money for.
Always late.
And right. Whereas now for the price of two of those films, I have a jukebox full of motion pictures and TV shows that I can watch at my command, and people still say, well, it's not enough.
People are never satisfied, but I'm a millennial, but I'm a developing country millennial. So
I think it makes a difference.
Yeah, technology took a bit longer to get home. But yes, it was really a different experience. Just to walk in the halls of the movie renter we had a place called Home Movies, very close to where I grew up. And we would go there on a Saturday afternoon, spend like 2 hours deciding what movie to watch. Sure. And then going back home. And it was quite an experience. But now it's different. Now we spend 30 minutes browsing, looking for something.
Right. No, I make that joke all the time in the house that we've switched from the channel surfing to just browsing the titles as they, just flipping the titles as they go by and still saying, oh, there's nothing I want to watch.
Yeah, exactly. We're never satisfied.
Yeah, which is, I mean, we joke, but it's also, I think it is part of this narrative of, and part of the reason I call the blog The Illusion of More is that, is this illusion that we, I want everything, and I want everything that has ever been written, said, sung, at my fingertips. You have to sometimes remind yourself that you're human and mortal.
Yes. Very important and limited.
And sometimes paring down what you consume might not be the worst thing you can do. There's such a thing as media gluttony, just like there can be any other food gluttony. You can. Yeah. And we see it with children, right? That's a conversation that's been, how many screens, how many hours in front of how many screens can they have before it has a detrimental effect? So.
Yes, of course. And everything of too much is wrong. So that is a weird translation of a Dominican say. I'm trying to say that everything that is too much is wrong at some point, because it's bound to make you harm in a way.
And except perhaps money, but
even that
can be, yes.
Even that, yes, that could be too much. Well,
in the wrong hands.
That's true. So, David, any final words to our audience? If they are a creator trying to make their content protected or trying to navigate this new copyright reality.
I do try to advocate when I meet creators or talk to other creators. I mean, it's one of those weird animals that nobody ever thinks about. It's a strange thing because, I mean, copyright's always been this sort of backwater conversation. And yet, ever since the internet and Napster, it's where it isn't a backwater conversation. It's a war. It's a battle that we see go on. But I think a lot of creators just don't think about it. And so, I mean, in answer to that, I think it's part of the reason I wrote the book is I think if you are involved in any form of creative work, whether it's writing or motion picture making or dance or anything, that having some framework for where those rights come from, a basic understanding of the history and a basic understanding of what some of the core principles are is probably a good idea. Sometimes I follow some chat boards and whatnot, and I see creators, authors, professionals make glaring errors in some of the advice they give one another on chat boards about copyright issues. It's not that you need to be an attorney, be your own attorney, but there's an extent to which, as you know, some authors have to be sort of their own attorney in some cases, like when they ask themselves fair use questions or they ask themselves, basic questions. At least having some framework for what the core principles are is a good idea, I think. Which again is not to say go and write your own contracts or sign them without counsel advising you, but it is a good idea. And don't listen to every rumor you hear on the internet. There's just a lot of confusion out there. There are a lot of, especially on topics like fair use, where you'll hear people say, I fair used this.
What?
Yeah, that doesn't. No attorney would look at you and say, "Okay, I understand what you're talking about." So that's my answer to your closing remark question.
But it's a great answer.
But I really appreciate the conversation and you reaching out and to talk about the book.
Yes, me too. And I really advise everyone who's listening to get your hands on this amazing book titled "Who Invented Oscar Wilde? The Photograph at the Center of Modern American Copyright."
And my publisher is published by Potomac Books. My publisher won't appreciate my not mentioning that.
And so we come to the end of our second season. Thank you for your time. Thank you for joining us, for listening in to all these amazing stories and amazing guests. We meet again on the third season.
Thank you for listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Did you like what we talked today? Please share with your network. Do you want to learn more about intellectual property? Subscribe now on your favorite podcast player. Follow us on Instagram, Facebook, LinkedIn, and Twitter. Visit our website www.intangiblia.com. Copyright Leticia Caminero 2020. All rights reserved. This podcast is provided for information purposes only.